Ron Peppe, and I'm the Vice President of Legal and Human Resources for Canam Steel Corporation. And it's one of those tricky issues because most companies, if they're not unionized, have never had to deal with the NLRB. They're now finding that they're all subject to certain regulations and rules and getting in trouble sometimes because they don't have a history of dealing with labor relations because of these new areas that the board is moving into. In particular, a couple years ago, the NLRB came out with some guidance on social media policies. And that's a very good example where companies get in trouble and don't even realize it because they put out what they think are reasonable policies about the use of social media by their employees. And it turns out that runs afoul of some of the NLRB guidance. Social media, by its very nature, is collaborative. People are talking to each other. And the National Labor Relations Act protects employees when they talk to each other about things. So employees post things, sometimes employers try and discipline them, they don't like what they hear, companies get in trouble because it turns out they're not supposed to be telling employees they can't do that. Including some fairly, what seemed to be common sense cases. There was a case recently that involved a large restaurant chain. The workers posted pictures all over the place of the food with a tagline saying, "This food can make you sick." The company fired them because they thought their employees shouldn't be out there telling people the food might make them sick, and it turns out the company lost that case before the court and was ordered to rehire the employees and provide them with back pay. The NLRB then recently issued guidance on employee handbooks and tackled a whole lot of other employee issues where companies typically have had rules. For example, companies might have rules in the handbook saying, be respectful to others, don't pick fights online, don't harass people. It turns out those kinds of policies can also constitute violations because, again, the policy saying don't do those things, the board thought inhibited the employees' rights to collectively talk about working conditions. Since a lot of companies in their handbooks have put in requirements that employees go to arbitration rather than suing over certain issues. And in particular, they do something called a class action waiver, where the employees waive their rights to enter into class actions and in return go to the arbitration process, which is much less formal. There have been cases recently, in general, upholding companies' rights to enforce arbitration agreements, but the NLRB has taken the position that any class action waiver violates the National Labor Relations Act. So you kind of have a split here where the courts under one set of laws are saying, okay, companies are going ahead and doing it, yet the NLRB is still insisting you can't do it under the National Labor Relations Act, even if it's legal under other provisions. Another place where companies get in trouble because they look at one set of laws and not the full range because they're not used to dealing with the NLRB directives. The problem is you really have to comply with all of them. So even though one part of the government says it's okay, we encourage arbitration, it's policy, the other part of the government says no, you can't do it. And so employers are in a tough position where they're attempting to abide by things and part of the government's basically saying you can't do it even though there have been findings that it's okay. It's hard for employees to quite often know what to do because, again, if they're not a unionized workforce, they're not used to looking at NLRB pronouncements, and so they might not even know about the requirements. So things like dress codes, at-will employment, a number of other very typical policies are all being challenged by the NLRB. What's interesting is the NLRB can't just bring charges on their own. So unlike the EEOC or other parts of the Department of Labor who can come in and charge a company, they can only do it in response to a complaint by an employee. But what they've done recently is if they get a complaint by an employee, they will then come in, go through the handbook, and find other violations that had nothing to do with what the complaint was about. So again, that's another change where you're seeing very broad enforcement once they come in and take a look at what's going on. The trick for companies is you got to step back, look at your policies, look at your rules, look at the things you're putting out there for employees, things that might seem very reasonable and that have been done for a number of years. The government is challenging now, so you can't just assume it was okay before and it's going to be okay now. It can turn into a very expensive fight if you're not careful about it.